Okay, let's dive into this. Picture this scenario, right? It's late, you're on the road, it's pretty empty, you're trying to be careful, but maybe you drift just a tiny bit. You touch the white line on the shoulder for a second, then maybe hug the yellow line. You're still totally in your lane, not swerving or anything, but is that enough to see those dreaded flashing lights pop up in your rearview mirror?
I mean, it's a question every single one of us who drives has probably thought about at some point. Can that little bit of a drift, that tiny bit of weaving, actually get you pulled over? Well, believe it or not, a really fascinating court case gives us a surprisingly clear answer.
So the case we're going to dig into is from the Ninth Circuit. It's called United States versus Colin. And the whole thing gets started, get this, at 2 o'clock in the morning. An officer is out on patrol and he spots a blue Honda.
Now, what's wild here is just how specific and, well, brief this whole observation was. The officer is about 75 yards back, and he only watches this car for like 35 to 45 seconds total. In that short window, the driver hugs the white fog line for about 10 seconds, then signals and makes a perfectly safe lane change. Then they hug the yellow line for another 10 seconds, and again, signals for a safe lane change back. And that's it. Seriously, that's the entire driving pattern that led to the traffic stop.
So, the officer sees this and thinks, that's suspicious, maybe a DUI, and that's his reason for pulling the car over. But once he's at the window, his theory kinda changes. He notices the driver and the passenger, who is Mr. Colin, look pretty nervous. He also spots an air freshener hanging in the car and a radar detector in the glove compartment. Suddenly, all these little clues make the officer's suspicion shift from a simple DUI to something bigger. He's now thinking they might be transporting narcotics. Okay, so with this new suspicion in mind, the officer asks a simple question. Hey, can I search the car? And they say yes. They give him their consent.
And right here we have to pause because this is an absolutely crucial point. I mean, the advice from pretty much every legal expert out there is crystal clear. Never, ever consent to a search. And you might ask why not? Well, it's because the Fourth Amendment is your shield. It protects you from searches without a warrant. But the moment you say yes, you're basically handing over that shield. You're voluntarily giving away that protection.
So, because they consented, the officer searches the car and he finds methamphetamine. The driver and Mr. Colin get charged in federal court. But hold on, the story is far from over. This is actually where the real legal battle begins. Mr. Colin's lawyer makes a big move. They argue that those drugs can't be used as evidence because the officer had no legal reason to pull them over in the first place. Think about that. It's a super high-stakes argument. If the initial stop was illegal, then everything that happened after it, including finding the drugs, could just be thrown right out of court.
So, the million-dollar question is, was the stop actually illegal? To figure that out, we need to back up a little and understand the legal rule for any traffic stop. And it all comes down to the Fourth Amendment.
All right, so the Fourth Amendment, we've all heard of it, right? It's our constitutional protection against unreasonable searches and seizures. And let's be super clear on this. The courts have said time and time again that when a police officer pulls you over in your car, it doesn't matter if it's for 30 seconds, that counts as a seizure under the law.
So for that seizure, that traffic stop, to be legal, an officer can't just operate on a gut feeling or a hunch. No way. They need something specific called reasonable suspicion. And what that means is they have to be able to point to actual, concrete facts. Articulable facts is the legal term that would make a reasonable person think that some kind of criminal activity is going down.
Okay, so now we get to the heart of the matter. The court put the officer's reasons for this stop under a microscope. So let's break down exactly what the officer said and how the judges analyzed it.
Basically, the officer gave two official reasons for pulling them over. Number one, he claimed the driver was breaking California's lane straddling law. And number two, he said he suspected the driver might be under the influence, a DUI. The court took these two claims and looked at each one very, very carefully.
All right, let's start with justification number one, lane straddling. The key words in that law are as nearly as practical. And that's huge, because the law isn't saying you have to drive like a perfect robot. The court looked at the situation and said, look, briefly touching a line right before you make a safe, signaled lane change, while you're checking your mirrors and getting ready, that is practical driving. So boom, no violation there.
Okay, so that one's out. What about the DUI suspicion? Now, the court didn't say weaving can never be a sign of a DUI. Of course it can. But they made a key distinction. The law is looking for substantial weaving. What they saw here was not that. The driver just touched the lines twice, for a few seconds, and then made perfectly safe lane changes. The court called this minor, not substantial, not even close.
And then there were all these other little facts that just totally weakened the officer's whole story. Remember, he only watched the car for less than a minute, and he was 75 yards away. But here's the real kicker. After he pulls them over, supposedly for a DUI, he never once asked the driver if they've been drinking. Not a word about it. He goes straight into a narcotics investigation, which really makes it seem like the whole DUI thing was just an excuse to pull them over.
So when you add all of that up, the short observation time, the distance, the minor weaving, the court came to a really clear and powerful conclusion. And this is a conclusion that has big implications for every single one of us who drives. And here's the verdict. The stop was illegal. Simple as that. The court ruled that the officer didn't have reasonable suspicion. That tiny bit of weaving wasn't a traffic violation, and it wasn't nearly enough to suspect a DUI. That means pulling the car over was a direct violation of Mr. Colin's Fourth Amendment rights.
So what happens now? I mean, the stop was illegal, but they still found the drugs, right? Well, this is where a cool legal rule called the fruit of the poisonous tree doctrine comes into play. The analogy is pretty straightforward. If the tree itself, which is the traffic stop, is poisonous, meaning it was illegal, then any fruit that comes from that tree, in this case the evidence they found, is also poisoned. And poisoned evidence has to be thrown out. The drugs couldn't be used against them.
So what does all this mean for you, for me, for anyone driving home tonight? It means you don't have to be a perfect driver. Slightly weaving inside your own lane is not automatically illegal. Briefly touching that fog line or the yellow line may not be enough to justify a stop. The police need those specific, objective facts we talked about, the totality of the circumstances, not just a hunch to pull you over.
And that kind of leaves us with one last question to chew on, doesn't it? This whole huge federal case came down to just a few seconds of driving and one simple question about a search. It really makes you think. If you were pulled over tomorrow, would you know exactly what to do and say? Would you know your rights?